everyone, and welcome to our last installment, at least for this bar cycle, of Ask the Expert, which is part of the Supplemental California Bar Exam Prep Series at JFK School of Law. My name is Professor Kimberly Rice, and why are we here? Well, as you've heard me talk about in the past, the purpose of Ask the Expert is to address controversial or highly debated bar prep strategies, get a better perspective from a highly credible source, a known expert in the field for the California bar exam, and to give you the best chance at success in formulating a strategy so that you can pass the California bar exam, because that's your goal, right? Not to become a professional applicant, but to pass the bar exam and become an attorney. So one of the questions that is often floated around during bar prep is, what does the bar grader want? You know, how can we make the bar grader happy? And there are so many different answers to that questions. There's a lot of rumors floating around about what bar graders want, what you need to do to make them happy so that you can get a passing grade. And I thought, what better person than to ask a person who used to grade bar essays for the State Bar of California. Wouldn't you agree with me, Jay?
I would say so, yes. Hear it from the horse's mouth.
So I would like to introduce to you, and I hope I'm saying your name. How do you pronounce your last name?
Bijlani.
Bijlani. Okay, I just want to make sure. I'd like to introduce to you Jay Bijlani of Esquired. Welcome.
Thank you very much.
Expert.
Thank you, Professor Rice.
And so, Jay, as someone who used to grade bar essays for the State Bar of California, why don't you first share a little bit about your background and what you're doing now, and maybe just a smidge about your bar exam experience in California?
Oh, sure. Yes. So thank you very much for having me. My background started off with criminal appellate law. So I'm very heady. I like to write. And so I also decided at the same time, while I had that practice many years ago, was to apply to be a bar grader. And of course, I was accepted, and I began grading for the state bar while I was working. And then a professor of mine said, you know, hey, you have some great knowledge here. Why don't you decide to become a academic success faculty member at a law school that I'm aware has an opening? So I then became an ASP faculty member, working with a lot of at-risk students in developing their skills, making them both bar ready and practice ready. And of course, they're not mutually exclusive, right, based on my knowledge as a bar grader. And so, I left practice quite a few years ago to focus exclusively on helping students pass the California bar exam with the unique insight that I can provide.
Awesome. And the name of your business is
Esquired. Yes.
Esquired,
yes.
And of course, I'll give you a chance at the end of our conversation. I'll give you a chance to tell people what it's all about, because looking at the book, it looks like it's pretty extensive.
I provide only comprehensive services, and it's simply because we leave no stone unturned. There's a lot that the bar graders are expecting out of you.
That's why we have you here. So first, starting with the essays, I'm just going to let you have the floor. What do the bar graders want in terms of essays? I know that's a broad question. I'm just going to let you go at it.
Yeah, my pleasure. Yeah, so if you first watch this video that I have on my homepage of my website at esquiredbar.com, you'll see that there's a YouTube video there. I explain very generally what are all the fundamental lawyering skills that the bar graders are looking for, as well as what is tested on the MBE. These skills are something that I reverse engineered off of my experience. So in short, we're looking at law knowledge, how well you deal with the rules, law application, how well you deal with the facts of a case. That's what we call the I and the A in IRAC. And then there's law expression, how well we organize our answer. Depending on what portion of the bar we're talking about, these skills kind of come into play and into balance, some more weighty than others, whether we're talking about, let's just say, essays or PTs. So when it comes to essays, One thing that is, and the state bar is very transparent about, is that the bar graders are engaging in very detailed calibration sessions. And what it requires of us is to be able to answer a question backward and forward as the bar grader before we actually start grading real life answers. Now, what we're looking for and what we discuss in these calibration sessions relates to those three fundamental lawyering skills. Again, that's something that I encourage you to know first. That's what we call in education learning outcomes. What are the expectations of the person who is assessing my work? And so from there, we work backwards. We look at, what it is that we value on a particular essay as versus what is valued on a PT versus what's valued on an MBE. As far as essays go, it's extremely important that you spot all the major and minor issues. Now, why is that the most fundamental of all the learning outcomes, the skills that the bar grader is looking for? Because think about what the bar exam really is. The bar exam is your gatekeeper to your license to serve the public in California. And so one thing that we need to do is to be able to see our clients' problems. And that means big problems as well as small problems. If we're going to miss any problem, if we can't see a problem, i.e. spot an issue, well, then we're going to be prejudicing our client, aren't we? So it requires us to be problem identifiers before we can be problem solvers. And that's the nature of being a lawyer. So identifying the issues, both major and minor, are extremely important. And it's not going to be based off of, let me throw in the kitchen sink and hope something sticks, because obviously your credibility is at stake as well. And you want to adopt a standard that allows you to spot those issues consistently, regardless of the subject, whether you're feeling confident with the subject or not so confident with the subject. And there is a standard, and it's a standard that is quite broad, but it's one that must match the bar grader's rubric. So it must be arguable, right? It's a standard of arguability. And we're not talking about winnability, but could I raise this with a straight face and argue it before a judge and raise it or put it in a complaint? And that's really what we want to see in terms of issues. Can you spot the issues? Okay, that's the primary skill. Why? Because if we don't spot the issue, if we don't know what the problem is, we can't solve the problem through rule analysis and conclusion. So issue spotting is the threshold skill. Otherwise, what you're going to have is a big hole in your answer for where the rules and the analysis should go. Now, obviously, if you just say, just spot an issue and just run to the next essay, is that going to get you to a good place? No, because of course it's where your starting point is. So once we know what is the problem, then we want to know how we're going to solve that problem. What tools does society give us to solve the problem? i.e., what are the rules? What rules am I working with? And then once you know what the tools are, what sort of analysis are we going to give it? How do we apply those tools that society gives us to our particular situation in detail, so that we can then come to a conclusion, a solution to that problem? And so it's a cascade, if you will. Now, I spoke about issues and the importance of that. What about rules? We have volumes of rules, right, to know of, and it goes across multiple subjects, some that we feel comfortable with, some that we don't. We're not looking for rule regurgitators. We're not looking for robots. We're not looking for machines that can think of every last rule that you picked up during bar review. And so what does that mean? What do you want out of me then in terms of rules? Well, on the essays, obviously it's inductive reasoning. You're going to go through that file cabinet in your head, and you're going to try to remember as many of these rules as you possibly can. So I'm talking about the essays right now. The PTs is different. The PTs are different. They're deductive reasoning. You have all the rules right there in front of you, and it's your job to assemble them in just the right way. So when you're talking about inductive reasoning, we're talking about relying on our memory. So yes, there's going to be a lot of memorization of volumes of rule, but something's got to give. You need to focus a bit more on understanding what rules the graders are accustomed to seeing. So the graders are going to bucket your answer in their minds and put your essay in a specific bucket because it deserved that grade holistically. And when it comes to rules and considering the rules as part of that holistic equation, they're looking for you to be able to take that rule and that in a way that pretty much everyone else sees. So if you don't see a rule in the way that everyone else sees, then you'll be sticking out from the placements of those buckets. So it's best to know, and you might have heard people say, okay, be a sheep, right? That has its limitations. Yes, you want to be a sheep in as much as what rules you're memorizing. So yes, in that context, go ahead and be a sheep. What you want to do is to know the rules, how everyone else knows them, in as much as everyone else knows them. What are the most common rules that we see? Well, the rules for the big doctrines, right? You're going to see homicide. Do you know all your rules on homicide? Versus, something that you don't see very common, the assessing the legitimacy of an executive order. Yes, that's been tested on essays. Now, of course, what do we do? Which one is going to give us our bang for our buck, even if it's not tested on the essays? We're all going to venture to remember the one on homicide, the one that pretty much everybody knows. All the big chunks of rule down to the very specific limitations, let's say on felony murder, right? Now, did we spend as much time memorizing that as we did with the legitimacy of an executive order? No. And so what happens before the grader? Well, we see a lot of answers that don't quite fit our expectation of what that rule needed to be on the legitimacy of an executive order. So what are we to do? Well, we're still doing the same old thing. We're going to bucket that answer, right? And it's not just about one rule in one issue. We're looking again at the whole thing holistically and saying, in the totality, where should I be placing this? In which bucket? And so obviously, when it's considering little rules like that and how everyone else did in comparison, you'll be in good company if you didn't quite remember that rule too. So you don't need to remember every last rule. There's a priority of rule, right? There's the rules that you really want to know are the ones that everyone else is going to know, and that the graders are going to be exposed to so that they can bucket you accordingly, bucket your answer. Well, that's the extent of rules. That's not even that important, provided that, hey, I can't think of any rules on this particular issue. What am I going to do? I can't remember one little thing that society has given us as a tool to work with to figure out how I'm going to solve my puzzle. How I'm going to solve this essay. Puzzles are for PTs, and I'll talk about that in a minute. But what am I going to do? Well, the essays are extremely fact-driven, and they may not seem like it because they seem rather short. They're mostly about 3/4 of a page long on average, right? So what are you going to do? You're going to say, well, that's not a lot of fact to work with. How am I going to weave that in? Well, you need to use quite a bit of those facts. The graders are expecting you to use 90% of those facts. And not just use the facts that you see right there in front of you in black ink. They're looking for you to make reasonable inferences and draw from the circumstances and tell us, well, what do you see? If we didn't put it in the fact pattern, is there something else you can say in order to satisfy the idea behind the rule? And that is where the lawyering comes in. That's where you're really being tested of that skill. Can you lawyer? Can we unleash you to the public and hand you that bar card and say that they'll be in good hands? And that's really what it is. The ticket is with your analysis once you've spotted the issues. So don't panic if you can't remember every last rule. It's not a game of memorization. It's about being a lawyer. And so, yes, knowing the correct rules would enable us to give a better analysis oftentimes. But even when we are on the spot and can't remember exactly what rules that involves, then what do? You try to get into the intent of what that idea is, of what that rule is, try to work with the more general concepts that you might remember relating to the rule and start extrapolating from there, right? So if you can't remember that the legitimacy of an executive order is based on what we call the ebbs and the flows from the Youngstown Sheet case from the 1940s under President FDR, which is, if you're curious, it's where you have an executive order is most legitimate when it involves a matter of foreign policy, as opposed to whether it's a matter of domestic policy. And it's also more legitimate when Congress has spoken in favor of such action, as opposed to speaking against such action. And you would assess it based on those two continua, those two balances, and to assess the legitimacy of an executive order. Now, let's say you don't remember that. Could you think of what was the idea behind that executive order? Well, I mean, the executive order is kind of the president coming under his or her or their
Mhm.
power as the chief executive, right? So could you say that he was acting or they were acting as under the chief executive power and say, well, I remember that much, that the president is the chief executive, and well, you know, that's all I remember. And the chief executive's job is to execute the laws, not to make laws like executive orders. Well, guess what? You would be in good company, right? Most people can remember that. Most bar takers can remember that. Maybe not the Youngstown Sheet test, but as they're going through, they are able to use the facts and work with the facts with that understanding of that rule. And that's what we want to see. We're never going to remember every last rule, but do we understand what's behind it? How do we do that? Is to take the best understanding we have and to go with it on the analysis. Does that mean on occasion you're going to make up keywords? Well, sure, right? And as long as they seem legitimate, as long as they seem like, you know, hey, this kind of fits with my understanding of that rule, even though I can't remember those exact keywords as I can, well, then, you know, you would be in good company again, right? So that's how the bar essays are assessed. So once you have your analysis and you've used all this data that's in front of you, the facts, and remember, those facts were vetted over time by the state bar and by lawyer after lawyer, professor after professor. They know what they're looking for and are enabling you to see things. They've purposely contained words in there. They've purposely omitted words so that you can make reasonable inferences. And so when it comes down to it, it's ready to go, can be answerable under timed conditions, and you then go for it and you show what you got analytically. Now, analytically, while we're on the topic, don't give us a listing of facts. Nobody likes that, right? I mean, the facts are given to you. I have the facts, you have the facts. Do we really need to see the facts on the paper? No, no one wants to see that. Don't, you know, if you see a fact that makes you go, you know, there was a 90s song, that things that make you go, well, that's one of them. You know, like, why did they say something like that? Why did they include that little detail? Be skeptical, like a lawyer would, and say, you know, how could I possibly use that somewhere analytically? Because the more you use those details, the more you stand above the rest, and that's how you get bucketed higher, right? It's your use of the facts. Now, so no listing facts, ping pong matches, that's something that we see a
Oh,
lot, right?
yes. Yes.
Plaintiff says, defendant says, plaintiff says, defendant says, or even just having a monolith of plaintiff's arguments and then defendant's arguments. No, duke it out one element at a time. right? And only give arguments that are colorable. Don't just throw any sort of silly argument. If you feel like you can't make that argument in court, don't make the argument. But if you feel like there's something crafty here, like I can really show off a little bit more of my analytical skill and read between the lines here, please do. Knock our socks off. That's how you end up in those higher buckets when you're really showing that you're an analytical lawyer, right? So lawyers need to be analytical. That's what we like. Now, your conclusions. Your conclusions don't always need to be correct, meaning that there's going to be some things that are there's no other way of looking at this one, and there's a firm answer on that. You should have a yes or no, right? Yes, there's a battery, or no, there's not a battery. So what do we do when things are nebulous? Pick a side. Still pick a side. And the majority of bar takers will probably say the same thing as you did. And some people would probably differ, but it's always going to be based on the weight of your analysis. So if you're doing a good job analytically and really thinking through the kind of crafty arguments the lawyers would be making as to each element, well, your analysis should be sound. And you should feel pretty comfortable with selecting it, even if it's kind of in a gray area. So pick a side for your conclusions. Now, I also talk about law expression in that other video. And so that's going to be about your organization. Organization shows that you're a credible taker, right? So it's not just, why do we organize certain issues the way that we do? Why do we organize, as an example I like to give, is duty, breach, causation, then damages, and not jump around and start off with damages and then duty and then causation and breach or whatnot. Well, there's logic to it. Show that your logical fluency with the substantive law by how you organize. I know that you need to be careful. That's establishing that standard of care, that duty, and to whom that's owed. I then want to assess whether the defendant had breached that duty that we just presented. Then were they the cause of it, actual, proximate, and then damages, and then defenses, affirmative defenses. So knowing the difference between a counter argument and an affirmative defense, also by the way that they're just simply organized, shows that you understand how the fundamentals of law works in that particular doctrine. So that's the synopsis on the essays. Do we have time to talk about PTs a little?
Oh yeah, I definitely, because a lot of people are afraid to practice PTs.
Oh yeah, big
They don't
mistake.
want
I
to.
know, we got to charge through our fears. Yes.
They don't feel as though they'll have enough time to put together a 90-minute performance test. So what say you on that?
Yeah, well, that is essential that you're able to get over that hump of PTs are scary. And the way we do that is to really say, look, all that the PT really is, when it comes down to it, is a puzzle. And if you like any kind of puzzle, if you have any sort of curiosity toward puzzles, which I love, it could be anything as like a jigsaw puzzle even, or Wordle, or anything that kind of like is a little bit of a brain teaser, the PT should be your strong suit. And it's not that complicated as long as you are focusing on that goal of solving that puzzle. Now, what makes it a puzzle? Think about that. The PT is a puzzle because it's deductive reasoning. Everything is right there in front of you. There's nothing to bring to bear from anywhere else but your basic understanding of the principles of how law works. And that's exactly what the general instructions in the PT tell you. They say, don't worry about anything. Make sure you just bring to bear your basic understanding of how the law works. Okay, so if I know that the difference between a counter argument and an affirmative defense, should that apply? That's what I'm bringing to the table, that sort of thing. So when it comes to the PT, everything is right there within the four corners of those two booklets, the file and the library. So what are you supposed to do there? So what does that mean? If it's a puzzle, there's a heightened emphasis on law expression, on your ability to organize. your organization should feel tip top. Think about how you solve other puzzles. Once you've kind of figured out all the pieces, your job is to make sure that once you've done that, you have this feeling that says,
Mhm.
hell yeah, or heck
Yeah.
yeah, I have solved that puzzle. You get that dopamine rush
You do.
when you're solving a puzzle.
Yeah.
That's the kind of feeling that you can expect from solving the PT puzzle every single time. You shouldn't feel stumped as so long as you have a really good methodology that enables you to see all those floating pieces and to combine them in exactly the right way as a puzzle would. Now, to claim to have solved the puzzle, you can't have missing pieces.
Mhm.
So the devil's in the details. You need to be able to, find the connections with all the little words that you see. And that comes through being able to identify in a variety of ways those key words that you keep seeing and repeating and being able to click them like the puzzle pieces click. And so that is very fundamental to a PT. And that's not just on that micro level. Can we see the relationships between each of these little pieces? It's also on the macro level. It's where you're kind of saying, can I understand? Am I showing a relationship of all the issues that I see that I'm presenting? And they should fit in neatly. And this really speaks to how um, you know, as I was a lawyer, like I said at the outset here, was that I practiced criminal appellate law, and everything was writing. Did
Mhm.
my judges really expected me to lay out all of the issues very cleanly for them to be able to read and in a very thorough, detailed way, without any missing ideas as relevant to the issues, and present. Now, what else did I do when I did that? Or in any context, it's not just about filing appellate briefs as you are tested on the PTs, memos of law, letters to opposing
Yes.
counsel, and even lesser common PTs like jury instructions. People like
Right.
get freaked out when they see those. So basically what it involves is that as a lawyer practicing at common law, it's not just about structuring, it's not about just including all the I's and the R's and the A's and all the right places and the conclusions. It's also about analogies and distinctions.
Yes.
That is what we do as in most areas of common law. We bolster the quality of our analyses in using analogies and distinctions. It lends to a greater persuasion based off of your perspective, whether even if you're writing objectively. We want to see what kind of arguments would be had and how are they well supported and grounded by facts of case precedent. And that's something that you need to be able to do working with those cases in the library.
Awesome. You have mentioned so many trigger words for me. You talked about keywords. That's something that I express to applicants all the time. I use the term keywords, buzzwords,
Mm-hmm.
that the bar graders are
I
going
do
to be
too. Yeah,
looking for buzzwords in the rules, because I have some people who want to memorize a perfect rule,
that's right.
but that's not what you're looking for, right?
No,
I
no.
just want to put that to bed. Okay,
That,
people,
yes,
if you're looking
absolutely.
for that, bar
Yes.
graders in California are looking for a perfect rule. So therefore, you have to study the rule for 5, 6 hours a day until you get it down. But
Absolutely untrue.
right,
Yes.
what I say
Yes.
is that you have to learn to apply the rule to a specific set of facts in
Yes.
order for it to in order for your long-term memory to make room for it, so you can recall it on the bar exam. Am I wrong there?
No, you are on point, and they should be listening to you on that.
Okay,
As
I
far
just
as,
wanted
of
to make
course, with
sure.
everything as well, right?
Okay.
So yes, you are absolutely right. Best case scenario, we know all our keywords, right? The words that are going to pop off the page for the grader, the ones that make that rule, and not knowing, like, to establish a prima facie case for,
Exactly.
no, sure, you can be bucketed maybe a little higher, or maybe you'd be, you know in in the context of bar grading, someone might say, okay, this person seems very formal, and that's fine. But it's more about what you do with those keywords. And that's what I do with my substantive law book.
Yes,
It's just the buzzwords.
please
It's
tell us.
just the keywords. Yes. So my outlines are succinct. Believe it or not, you can get, uh, on average, an outline to be 17 pages long per subject
Wow.
and be in keyword format.
Well,
And
let me share a picture of that again, because I want people to actually see it.
I appreciate that. Yes.
It's in the picture. Let me see. Let
Yes.
me start the slideshow so they can
Yes.
see it. Let me go through this really quick because I want people to see what the book. Oh, there it is. That's your book.
That is, yes.
Yeah.
And of course, I updated for every bar season. You know, there've been a lot of updates dates recently in constitutional law.
Oh, yes.
Yes, and there will continue to be. And so obviously, as I know they are being tested by a particular, as of a particular bar administration, of course, those updates will be presented in keyword format. So of course, this is real law that I have gathered and put into keyword format based on how, on the lens, through the lens of the bar grader. This is what I did as a bar grader, and what did I want to see as far as how I viewed individual rules, general rules, etc., the hierarchies, the relationships. I pay very close attention to all of that, and it's entirely comprehensive. It's not just for essays, it's one singular source for MBEs as well.
Oh,
And that's
awesome.
what we need. So yes, you can condense your outlines to, on average, 17 pages and have enough substantive law to work with to kill it on both essays and MBEs.
You know,
And so
I just wanted to jump in here because I mentioned to a bar applicant several months ago, I showed them my torts outline from the first, I took the bar exam twice. First time I didn't do anything right. The second time I did and passed. You may have graded my essay, I'm not sure. But the first bar exam I took, my torts outline was 36 pages, entirely too long. I did not need that content, and some of that content was from law school.
that's right. Yes, you want to be very careful. Unfortunately, it's a highly unregulated field, and we're not really told to what degree we need to know the law, let alone have that law pre-distilled for us. And so spending all that time in lectures and trying to assemble your own outlines, unfortunately, is the misfocus here. And why? Because what's most important on essays? Issue spotting and analysis. It's not even the law. The law is a vehicle for that. And obviously, you want to know as many of those keywords as you can, but in as much as you're not able to, well, there's a hierarchy there of what rules I need to know, as I said earlier. On the MBEs as well. You know, many of us believe that as long as I know and I know this isn't the subject of what a bar grader wants, because bar graders don't look at your MBEs, that's all Scantron. But with the MBE, it's that yes, you want to narrow it down to the most specific rule elaboration that you might have on your outline, but you're going to fail to see all of them. So what do you need to be able to do? You need to be able to incorporate that same skill that you have on essays and make those, finish that arc. Basically, based on what rule I know, you know, let's say executive orders in general and the executive power of the president, even though I can't remember that very specific rule, even if it's implicated on the correct by the MBE choice, I can still argue that one out in my head and really explain how and justify that answer choice that I feel like I'm going for. And it's that's the 10,000-foot view, and it gets more sophisticated, but you don't need to know every last rule verbatim, even for the MBEs.
There's something you just said about the MBEs that triggered me again, and it just went out of my head. You were talking about, the narrowness, and I constantly refer to the narrow rule
Yes,
being tested, and you also talked about kind of IRACing in your head.
that's
Well,
right.
I've been encouraging applicants, that when you do an MBE question, what you're essentially using the same tools that you're using in an essay. You've got to IRAC it out in
Exactly.
your head, come to your own conclusion, go to the answer choices and look for your answer. Don't depend
Listen,
on someone else to give you the answer, right? So am
yes,
I right or am I
you are
wrong?
absolutely on target. With my students, they each of them understands the parallels very clearly between the essays and the MBEs, as you're saying. And that is extremely important because I would say about 35 to 40% of MBEs are not just answerable by a casual understanding of the rule and a casual understanding of the fact. You notice that many of us hit a plateau on MBEs, roughly maybe in the low 60s, often sometimes in the upper 50s, and it's because we lack the intensity of the analysis that we need on the MBEs, which oftentimes we can do more easily on essays. Just let it rumble, right? Just let it go. But on MBEs, we kind of seize a little bit and say, whoa, wait a minute, what was that rule? And let me kind of justify this without really treating it for what it's designed to be, which is something that is uh, an essay type answer. It's an argument and it's a counter argument. And believe it or not, you also engage in skills of analogies and distinctions. And this is something that my students and I practice quite a bit, and with that understanding can start to see really good scores. So
You
that's
just
what I want you to do, is look at it more analytically than more rulely. I know we come from law school and we try to please our professors. Oh, what rules does my professor want to see? Let me put my outlines together. It's all about the rule. But one of my favorite professors in law school said to me, welcome to fact school, not law school. We're here to work with the facts. And that's what
exactly.
a good lawyer does. And
That's
that's
exactly right.
exactly, it's the entire arc
It's the
of
facts all day. They
all
rule.
day.
Facts rule. And there's another word that you just said that I say over and over again, but I'm not sure if people are really listening or understanding. I keep saying the word practice.
Oh, yes.
We talked
Well,
about
how else are
practice
you
with
going?
this.
Yes,
No
abs-
other way to do what the bar grader wants you to do
you've got to
except
practice.
to practice what you've
That
just talked about with
that's
us. There's no
absolutely
other
true.
way.
There's no other way. How else are you going to consistently spot the right issues on an essay?
Right.
How else are you going to train your mind to be analytical when you see a certain set of unique facts and apply the same rules you've seen before and understand what those rules mean and take the facts to a place where you can come to a just solution, a just conclusion? And that's what we're here for justice. So we're working with the specific facts of a client in real life. We're really listening. We're really trying to gather that information so that we can come up with these creative arguments. Some students think that the bar exam is too clinical and doesn't allow for creativity. It's quite the opposite. It's about working with the facts. And the only way that you can do that is by copious amounts of practice, not sitting in front of a lecture, understanding the rules. That's something that you should have already distilled for you in 17 pages on average, and you should be able to understand that body of law in a very clear way so that you can be able to apply it well. So you need to spot the issues and you need to analyze, do the application. Those are the two most important skills that the graders are looking for on essays. On the PTs, the two most important skills are solving that puzzle, trying to find where everything goes, and then again, it's your analysis. And which also gets more detailed by the fact that you're making analogies and distinctions to case precedents as frequently as you possibly can. It's also about MBEs. Once you kind of understand the rules, can I argue it out and justify it? And again, that only comes through practice, not by passively listening to lectures, which is something that I don't do. So
Exactly.
it's important, and you get the real feedback on what the bar graders are expecting.
You know,
That having great feedback is important.
the difference between bar exam number 1 and number 2 for me, it came down to one word:
It,
practice. It came down to the first one. Not enough practice at all, not nearly enough practice. The second one, I don't know. It was like, no pun intended, but it was like I was at the Super Bowl. No pun intended, but it was like I was going to my Super Bowl.
Yes,
Because
yes,
think about, the teams that are playing in the Super Bowl, right?
yes.
How did they get there?
Yeah, well, I don't know,
They
but
didn't.
yes, it's the, and also for me, if you even think about it, the halftime show, which is what is more interesting to me than the Super Bowl itself.
It will be
How
very
did the
interesting.
performers get there, right?
Exactly.
It's
Yeah,
through the practice,
how did
right?
they all get there? They didn't just walk onto the field
That's
cold.
right.
They didn't walk onto the stage cold. Months and months and years of practice
And
over
I
and
understand the
over and
mental
over.
block. There's a mental
Yeah,
block. We know that we need to practice, but how do we get ourselves to do it? So, well, accountability is important, and part of it is self-accountability, and part of it is like, checking in on like, knock, knock, how are you doing there? I haven't seen much from you. And so, pushing and getting the students to be able to do that. And also it's about desensitizing, is to demystifying the bar exam, which is what we're doing here today, talking about like, what is really important here, breaking it down into bite-sized pieces, and to say there are very severable skills that one could view the bar exam as testing. And where are my deficiencies? Well, I'm not all bad in this area of law versus that area of law. Or like, what I don't like is when blanket statements get thrown around like, I'm bad at property, I don't get property. You sure about that? Can you talk to me about easements? Do you know easements? Oh yeah, I know that. Do you know adverse possession? Oh yeah, I know that. So then what exactly about property? Oh, it's conveyancing. Oh, okay, conveyancing.
right.
Let's talk about conveyancing.
Yeah.
What do you not understand about conveyancing? How are you going to improve on that? And we're all here to just practice that through to the point where we feel as comfortable with conveyancing as we are with easements and adverse possession or torts, any torts.
Exactly.
So it's about demystifying it. And it only happens by breaking down that practice barrier, that barrier to not practicing enough.
Well,
And there are ways to practice in easy ways, quick and easy ways. And I'm not just saying, oh, let me just spot issues. No, because issue spotting is only one skill, but to practice very efficiently and still speak to each of those fundamental lawyering skills and really know how well you're doing, self-assessing on each of those.
you know, I could talk to you for
We could
hours.
go on, I know.
We
Yeah.
could go on. You just said something else too, self-assessment. I say that over and over and over again because that's a way, in my mind, doing a self-assessment is kind of like putting yourself in the mindset of the bar grader, kind of.
That's exactly what I tell my students. Let me turn you, in my first session with each of my students, I say, and it's always one-on-one, we always talk about, okay, let me turn you into a bar grader.
Yeah,
And then we go through how to self-assess,
that's the
because there's
best.
a lot of that.
That's one of the best ways of active learning. And like I said, I could talk to you for 3 hours.
Yeah.
I've got to go look at some facts and I've got to do
Yes.
some analysis myself as an attorney.
That's right. Yes.
So I've got to go to work, but
Yeah, no, I
yeah.
appreciate that.
But yeah, I want to thank you again for coming and doing this last episode of Ask the Expert for the February bar cycle. I know that your applicants will do extremely well. I hope that the applicants that I've been talking to will do extremely well. And we'd love to have you back again.
I'd love to come back. Yeah.
And to talk more and more and pick your brain, because it's rare that we actually get to talk to somebody who has graded bar exam essays in the state of California and who's not just talking air, but is talking from experience, actual
Absolutely.
experience. So
Yeah.
thank you so much for coming, and
Thank you.
enjoy the Super Bowl.
Thank you. And thank you for having me. And I want to wish you all good luck on this. And it's not as much about luck as it is about skill, I like to say. But, there is always an element of that. And I hope you all do extremely well.
Thank you.
Take care.